It's the Giza, the always the get flizza, the whizza, decking the boy izza, tizza, destined to get the winses, finses, clearing up all the lenses. One path is the way that I'm taking, getting closer to God in a tight situation. And here we go with part four of the Paper Arrows series. Part four of the Paper Arrow series. Lay out the cases. There are two ways to lay these cases out. One way is the counter complaint. All places where there is a complaint filed must be answered by a counter complaint. Rule 12 of the Federal Rules of Civil Procedure is one that these cases are based on. The state rules state the same words as the federal rules, but the number of the rule may not be 12. It may be 5 or 10 or another number. It may also be Rule 12, as in the federal rules. You have to check the rules out for each state. They are uniform throughout the states. They are basically, they use basically the same wording. Rule 12 states that you must see Rule 13. These rules run you all around. Rule 12 states for the responsive objective, see Rule 13. Rule 13. Rule 13 is headed mandatory counter complaints. Counter complaint mandatory. Since it is mandatory, that since it is mandatory, then that is what expresses the meaning that the response has to be done in the form of a counter complaint. Otherwise, it does not answer the complaint. It is absolutely mandatory that you file a counter complaint. It goes on to explain that the counter complaint has to be filed prior to the final judgment. After judgment, the counter complaint is barred. We cannot bring any old cases back by counter complaint. That chance has passed. When you do not counter complain, you do not answer the complaint. Rule 13 shows how to lay out the case. It cross-references back to Rule 8. Rule 8C. Rule 8C is titled Affirmative Defenses. An affirmative defense seems to be a contradiction of words. An example of the difference between an affirmative defense and a common law defense can be illustrated by my being accused of stealing a bicycle. Common law defense. The common law defense would be for me to state, no, I did not steal your bicycle. That would be my answer, my defense, that in common law. Now I have thrown the burden back on the plaintiff to prove that I stole the bicycle. In common law, the accused is always innocent until proven guilty. If I failed to answer, the silence would have been an admission of guilt or fraud or such acts. It would not have had to go any further. Modern law uses presumption. It does not work that way in modern law. In modern law, the rule is presumption. The court must presume the facts of the complaint presented are correct until the defendant presents evidence to rebut the presumption. Common law must have gone somewhere. In the case here, the defendant has to prove his innocence, so he is guilty and still proven innocent. That is the same way the system works, backwards. Affirmative defense. That is why they put in affirmative defense, so that you could admit that you were guilty. Then you defend yourself by saying, yes, I stole his bicycle, but he parked it in front of my house and left it there for 6 months. I thought he abandoned it, so it's his fault that I took the bicycle because he left it there for me to take. That is affirmative defense. I am not guilty. I created rebuttable evidence. Must tell the court. The court does not notice until you tell them. That is why you must affirmatively answer. They do not know that the other party is negligent, that he perpetrated a fraud. They do not know that the other party contrived or created a device or an artifice to get you involved in something like this. This fits exactly to show you how you can be induced into these schemes or scams, and your property has been stolen and you become liable because you did not use your property correctly. Once they are the holder and they put it up as collateral, they must make sure you maintain it so that the value of the collateral does not drop. They might have to pay back to borrow money, permits. So they make laws regulating how you take care of your property. That is what automobile laws are all about. That is what building permit laws are all about. They want to make sure your property is well maintained so the collateral value remains high, so they do not have to pay off the debt for the money that they borrowed against it. I do not like the fact that they have taken unfair advantage of me, and I am mad at myself for letting them get away with it. I let them do it. Now I am in defensive mode. The government's claim is that I did not abide by the things that I agreed to. I did not even know that I agreed to do most of these things. Look at the front of a certificate of title. It states the above named person is the owner of the vehicle described hereon and agrees to operate this vehicle in accordance with the laws of the state of Georgia. They tricked me into agreeing to go along with their laws. Now they will take me into court because I did not know what I agreed to do. Not because I did something wrong, but because I did not do what I agreed to do. They have obligation to tell, but I only agreed to do it because you did not tell me what kind of scam you were getting me into. And under the law, they have a good faith obligation requirement to tell you about such scams, that they are using your property to borrow money against it, and that you are going to have to keep that property maintained under their rules so that the value of the property is kept up. They did not tell me about all of this. If they had told me about all of this, I would definitely not have done it. 26 USC 911. CFR 1.911. According to Title 26 USC, the IRS Tax Collection Laws, Section 911, the corresponding CFR site is 1.991 under the heading Citizens and Residents with Foreign Earned Income. New York, read Merriam. We know that the United States is a foreign corporation with respect to a state, small s, because the state is a foreign corporation to the United States. See again, New York, read Merriam. 16 SCT 1073, that held the U.S. as a foreign corporation with respect to a state, small s. Enright versus U.S. shows that the federal government is a state of. If I lived in a state and not the state of, because I am not a member of the state government, then I am foreign to the United States and the state of, due to the fact that the state of is not foreign to the United States. The state government is not foreign to the United States government, since it is an instrumentality of it. This was the result of the 14th Amendment in 1868. Only the states is foreign to the United States, and that is the people that live in the vast countries known as Georgia, Arkansas, Florida, Texas, and the rest are the state of. The corporate entities, the corporate body policy. Jurisdiction. We found a case in Maryland that stated it was dismissed for want of jurisdiction. A way to find out how they have jurisdiction is to look at why they did not have it. Look at it from the other side of the coin. The case is about a man who sued the state of Maryland Board of Education in Carroll County. It was dismissed from Carroll County Circuit Court for the state of Maryland for want of jurisdiction. This was the state of Maryland Circuit Court. This would mean that you could not file a case in the Circuit Court against the state of Maryland. We did not understand. So we looked up the cross-reference case, and it was about another man who brought a case against the Board of Education of the state of Maryland in the Baltimore City Circuit Court for the state of Maryland. It was dismissed for want of jurisdiction. We were getting the idea that either you cannot sue the state of Maryland or you cannot sue the Board of Education. Why were these cases being dismissed for want of jurisdiction? Why were the cases being dismissed when the people were suing the state? We found another cross-reference to a case that stated, see this case for establishment of jurisdiction of suits against the state of Maryland. It stated that all suits against the state of Maryland must be filed in Anne Arundel County Circuit Court for the state of Maryland. That was it. Annapolis is the capital of Maryland and is located in Anne Arundel County. Must sue where located. And the corporation known as the state of Maryland has its headquarters there. You must sue in a jurisdiction where the party is located. The state of Maryland is located in Annapolis. The state of Maryland is not located in Maryland. It is not Maryland. It does not comprise all of Maryland, but it is a corporation in a building in Annapolis in Anne Arundel County. State is just an office. The state of Maryland is not a piece of land comprised within the boundary lines, known as state lines. As noted in the state constitution, that is Maryland state. It is nothing more than an office for the corporation's headquarters located in Annapolis. This is true for all the 50 states, not just Maryland. The state of comprises only that corporate entity located in an office in the respective capital cities of each of the states. It is just an address and only an address for an office. Hafer versus Mello. One point to remember is that when filing a suit against a government official, the suit must be filed where the official is located. And in the case of Hafer versus Mello, the U.S. Supreme Court decided that Mello and his former employees had an absolute right to sue Ms. Hafer for firing them from their jobs. She had no governmental immunity whatsoever, only because they sued her in her personal capacity. Difference was how case filed. Had they not sued her in a personal capacity, she could have claimed immunity in her political capacity. The court explains clearly that it was not a matter of what capacity she was operating in when she did the act that she was being sued for, but the difference was the manner in which the case was filed. No immunity. It was filed in her personal capacity, and she had no immunity because of that wording. Do not sue them in their political capacity, but sue them in their jurisdiction where they did the act. Counterclaims. Some of these cases involving non-resident aliens are going to require counterclaims against these governmental people in their personal capacities. The reason is that everyone in the government has the same silly beliefs that we all have had for all these years, that we are all citizens. And they think that they are doing the right thing by trying to collect the tax and other fees from all of us and themselves. Residents in government. If you are a doctor, dentist, electrician, contractor, nurse, or anyone with a license, you promise to obey the rules to get that license from the government. You signed your name on the document and made yourself a party to the government. You became resident within the government because now your signature is on a document that is in their files. So colorably, you are now within the government. Now you are not a resident alien. You are resident. But the source of income is what determines whether or not a tax is due. It is not always determined by your status. Status and source. A non-resident alien has both his status and the source of income to show that there is no tax due on the money earned. It is not so much that income was made as it is whether or not it was made from sources within or without the United States, the government. Foreign income. Likewise, foreign earned income from a state or other people that are in that state that are foreign to the United States would be from a private source foreign to the government. It is not taxable for residents or for non-residents of the government. Even though you may have a license to work, which would ordinarily make you taxable, you have to pay taxes only on money earned from within the government. Work for me. If you work for me and got paid for it by me, you would not have a taxable income. If you built in addition to a military base and got paid by the government for it, you would have a taxable income. 1040 form, 2555 form. So you would fill out a 1040 form showing the taxable income on the 1040 form. And according to section 1.911 CFR, explaining section 911 of the IR code, it states that you fill out a 2555 form, which shows the gross income, the total income that you had, and breaks down each source. It allows you to give the explanation for why the total amount on the 1040 form equals that amount, equals the amount that was from sources within the government, and their part was the only part that was taxable. And that is why that little bit is all that is shown on the 1040 form. There was an exclusion amount here. They allow you to deduct only $70,000 a year in private source income. Anything over and above that, they figured that you made that due to your privilege that you got for having a license, and they asked you for a tax on that amount over $70,000. There are not that many licensed people that have income from private sources that will be greater than $70,000 a year. There are some, but not that many. Most people will be exempt from taxes on their government income up to $70,000. Counter. You must be ready to prove all of these points that we have mentioned so that if they come down on you, then you can counter them. The IRS filed a summons and complaint for a man in Delaware to come in and show records and handwriting examples. So we went in and showed the records and gave the handwriting examples. The records indicated the W-2 forms he had from the corporation he worked for, not an officer of corporation. We explained that he was not an officer of the corporation that he worked for, that he was a worker. Corporation maybe, but he was not an officer. But this is the amount of income we did not try to hide. We did not try to hide that. The IRS said that they would be in touch. Summons and complaint. We went to the United States District Court and filed a summons and complaint for the IRS to produce evidence that this man's income was effectively connected to a trade or business within the United States. They asked, we asked. We used the very same document that they used, a summons and complaint. They asked for books and records, so we asked for books and records that show the money earned is from a source within the United States. Prove. If the IRS cannot prove this, they will not be able to proceed in the criminal case. This is called countering them. This is just like a chess game. Counter complaint. When you counter a complaint made in court, the prosecutor that would originally come against you becomes your attorney in the counter complaint. The counter complaint must be ruled on first. If it wins, the original complaint goes away. If the original complaining party does not answer or show up in court, the case can be dismissed for failure to prosecute in a timely manner. Criminal complaint form. When addressing any criminal matter, such as disturbing the peace, if you are charged, the rules state that all criminal cases must originate in the lowest level court. So you go to the lowest level court and ask them for a form for a criminal complaint. Dismiss. Then check in the criminal code statutes for your state and look up what kind of law they broke. Then charge them. If they fail to show up, the case will be dismissed with a motion based on a failure to prosecute timely. McLaughlin, probable cause hearing. There's a civil rights decision, County of Riverside versus McLaughlin. The Supreme Court narrowed down the Fourth Amendment meaning of a right to a probable cause hearing so that you are safe in your house and effects and property and papers. They noted that you could be arrested and held on a claim of some kind for not more than 48 hours unless there was proof of probable cause. 48 hours. You must also be arraigned properly and given the right to a lawyer, which matches what was held in the Miranda decision. So they combined Miranda and said you have to be arraigned in 48 hours. If they are going to do that, then we should be able to demand a probable cause hearing. Another man in Delaware got locked up for driving without a license. He demanded a probable cause hearing when he was arrested. They refused. He demanded it again in jail and put it in writing and gave it to them. They continued to ignore him, but he would not sign the bail release. Very important. The McLaughlin case, when the justice of the peace decided what he would do was send him from the lower court to the JP court to the next higher court. He appeared the next day in front of the higher court, the Court of Common Pleas in Delaware. The judge called the case. He said, "Are you Mr. Keating?" He said, "Yes." The judge then asked, "Do you understand the charges against you?" Mr. Keating replied, "We are not here to talk about the charges against me." The judge said, "Oh, yes, we are. They must have jurisdiction agreement." Mr. Keating said, "No, sir, we are not. If you would show a waiver of my right to be heard in the Justice of the Peace Court, I have signed no request to come to the Common Pleas Court. This court does not yet have jurisdiction. The Justice of the Peace sent it over here. But I did not ask to come over here or sign anything to agree to come over here to this court." The judge looked through his file and could not find anything that would be a request or agreement to come to his court and said, "You are right. This court does not have jurisdiction." And the case is remanded back to the Justice of the Peace. This case is remanded back to the Justice of the Peace. The Justice of the Peace could not get him to sign the consent paper at his court, so he sent him to the higher court. He was hoping that the higher court judge could coerce him into signing his consent. Fraud and traffic issues. The case went back to the JP court and has this probable cause demand still there. The probable cause demand stated that Mr. Keating wanted the plaintiff brought in according to this written demand, and further stated that the complaining party must appear at the probable cause hearing to show cause that this complaint is not based on the fraud, misrepresentation, and emanated from the unlawful conversion of the collected taxes from the people at large and using that tax revenue to purchase the land, constructs road thereon, and then deeding the said land to the corporate state government of Delaware, which results in a profit or benefit to the corporate state by deeming it a privilege to use that property. The JP was so mad and frustrated that he was throwing books and screaming. He put on a scene and threatened Mr. Keating that he would never get out of jail if he did not sign this bail release. He said, "If you do not sign this today, I'm going to make the bail $1 million. You will never be able to get out of this jail." Mr. K said, "I do not give a damn if you make it $1 billion. I'm not going to waive my right to the counter complaint, and I'm not going to consent to your fraud and coercion." The JP said, "Take that man out of here. I'm going to write an order that you will show up in court, in the Court of Common Pleas on the 12th of the next month. Release him." Now, what good would that do? The CCP already knows it does not have jurisdiction. It said so. He was so frustrated that he could not get this man's consent. Must sign in. There is no jurisdiction in any courts unless you sign in. A civil complaint has to be signed by you in order to get the complaint going. That is how you create jurisdiction for the court, by signing the complaint. In a criminal complaint, such as a traffic ticket, the cop signs the complaint, but you sign your consent. And if you do not sign in your consent, they cannot put you on trial. Rule 19. Here is the rule in Federal Rules of Criminal Procedure. Rule 19. You must watch how it is hidden in the words. Rule 19 states, in a district consisting of 2 or more divisions, the arraignment may be had, the plea entered, tried at any time. Then it states that Rule 19 was abrogated, not repealed, effective July 1st, 1966. Because of the 1966 amendment to Rule 18, eliminating division venue of, that would change the whole perception of what is actually stated here. Most important part here. We will read Rule 19 again, but this time we will do what the amendment states and eliminate division venue as it was originally mentioned in Rule 19. We will then start reading at the arraignment may be had, the plea entered, trial conducted, and sentence imposed if the defendant consents. Read it again. The arraignment may be had, the plea entered, trial conducted, and sentence imposed if the defendant consents. If the defendant consents, sign in. If you do not sign, so they will tell you that you will never get out of jail. A good response to that is, I just hope the food is good I needed some rest anyway. That backs them off. Another guy had already been arrested and put in jail for criminal charges by IRS for willful failure to file that were filed in district court, and he had signed a document known as order setting conditions of release, which is what he has signed in order to be let out of jail. He signed it. Agree to bail means agree to sentence. Here's what he agreed to. Acknowledgement of the defendant. I acknowledge that I am the defendant in this case, that I am aware of the conditions of release. I promise to obey all conditions of release, to appear as directed, to surrender for service of any sentence imposed, and I am aware of the penalties and sanctions for the above. I agree to appear for the sentence imposed. Why bother with bail? Why bother with the trial? If when the sentence runs out, you can let me go. Trials are expensive, and so are lawyers. The best thing to do will be to skip the expense and go to jail. There is no need to pay a lawyer. That is a standard form. If you sign to get out on bail, you will sign this form. If any of you have been in jail and got out on bail, you sign this form. Consent. That is how you consent, by signature. So we were refusing to sign. This guy in Pennsylvania said that he wished he had heard about this a couple of weeks ago, but it was released, and he wanted to know what he could do about it now. Revocation of signature. There's a signature was coerced out of you, or by some fraud or intimidation, you were prompted to make a signature that you would not have normally made on your own. That gives you the right under the law to revoke your signature. This fellow named Reese looked it up and used it and revoked his signature on the bail release document. Now he was worried that they may come throw him in jail because the signature was removed from the agreement, and they may want to take him back to jail until the trial. But that never happened. So we showed up at the trial, and the judge called the case to begin trial, and the guy told the judge that he could not start the case. The judge asked why, and Reese told him that he had revoked the signature on the order setting conditions for release. The judge turned to the United States Attorney and ordered him to come back in 10 days and show proof that he had jurisdiction over this man. The U.S. Attorney came back in with the crying plea of objection under Rule 12. She filed a counter-complaint against the judge's order, not against our man. He had not done anything. It was filed against the judge's order. She complained that the jurisdiction had been established by Title 26, Section 7401. Need consent. Should have counted her counter because in addition to Title 26, she would need his consent. But we forgot to do that. So the judge let it go and ordered the trial will start. Trial the next morning. They took him to court in handcuffs. When they got him in there, they took the handcuffs off. They placed the jury and got the trial. They picked the jury and got the trial started. The U.S. Attorney got up and gave the opening argument to the jury, and the judge asked Reese if he had any opening argument to the jury. He answered by saying that he was not going to have anything to say to the jury or anybody else until they can prove they had jurisdiction. He told the judge that he did not have his sign. He might participate in their trial. In the meantime, they had not established that they had jurisdiction. The judge said, "I know that. We will answer that question a little later on. Are you going to talk to the jury or not?" Reese replied, "No, I'm not talking to anyone." The trial continued, and the witnesses were called. And one witness told the court that Reese had an income, but the witness did not put in any evidence as to the source. Produce source. If a trial is necessary, be sure to require them to produce evidence as to the source. If they do not proceed with the trial, keep on questioning if they had any evidence to prove jurisdiction over the person. He did that. The judge said there's no jurisdiction established yet over you. Ask him a question about the testimony. Reese said, "No, if you have not established jurisdiction over me, I'm not asking any questions." The trial continued, and another witness was called, and then it was time to go home for all but him. He was to go back to jail, and the judge told him that he would probably rather be home in bed instead of going back to jail. And he said, "If you would tell me that you will agree to show up here in the morning, I will order them to let you go home tonight." Reese thought about it a long time and said, "Yeah, I will be here tomorrow." At that point, the court clerk said, "I got it. It is on the record." Then Reese realized what he had done. He just consented. When he agreed verbally, it was as good as a signature on a piece of paper to come into the court the next day. Reese then demanded a 10-minute recess. With reluctance, the judge gave it to him. On the third request, then Reese went to the back of the room, and with the help of some of his friends, he wrote up a revocation of his verbal consent. The longer he sat and thought about how the judge had tricked him, the madder he became. He went back to the bench and said to call the court back, and the judge did so. In session, Reese walked up to the bench and slammed the paper down in front of the judge and said, "Here's a revocation of my verbal consent that you just tricked and coerced me into, and I'm not putting up with any more of this nonsense. I am leaving." He walked out of the courtroom, right not to participate. The judge choked and sipped water and choked again and was not sure what to do. After several minutes, he turned to the jury and said, "This is a little bit unusual, and I am sure you do not realize what you have just witnessed. But you see, he had a right not to participate in this trial. Tonight, we are at recess, and we will notify you later as to what time we will continue this trial tomorrow." They proceeded the next day without him and got a conviction. They called him in for sentencing, and he did not show up, so they sentenced him without his being there. They wrote him and asked him to come in for sentencing. He wrote back and said that he did not want anything to do with the trial, and he did not want to take part in their sentencing either. The U.S. Marshals came out and got him. They took him to federal prison in Pennsylvania. Order of commitment. Then Reese subpoenaed the judge for an order of commitment. There was not one, so he warned the marshals. He told them that they would be liable since they were holding him without an order, but they claimed that they were not liable. He told them that he would get them and that they better go get their lawyers. They asked him if he had any health problems that they should know about. He told them that he had a wooden leg and that he had nothing but kosher food and fresh fruits and vegetables. So they brought him the foods he requested and had to replace his worn-out leg. They are holding Reese without an order. He should bring up a civil rights issue. This could develop into something big. We will see. Deprivation, discrimination. If they try to keep us from filing these counter complaints, that amounts to an action by them causing a deprivation of our right to utilize the court. This would be discrimination against aliens. Only a government flunky can file a criminal complaint. That means that a non-governmental person is being discriminated against. Aliens. Back in the 1980s, I found that aliens had more rights than citizens did. Or aliens have more rights. At that time, I thought it was a citizen. I thought I was a citizen and wondering how these aliens could have all these rights. In a book about equal protection laws of the 14th Amendment, civil rights claims on aliens in battles with the government and how the government abuses their rights. Personhood, natural person. In the same book, there's a section called Rights of Privacy and Personhood. To be a person is to be a government official, or a person could be a corporation, or a person could be a natural person. A government lawyer will take the presumption that when you admit to being a person, that you mean a person in government. That is advantageous to them so that they can prosecute you. You must clarify that you are a person not connected to government, then you are the other person in the law and are entitled to personhood with a life plane or lifestyle in this country. Shapiro versus Thompson, right to travel. Then in the same book, under the subject of travel, there's a court case here that says, concurring in Shapiro versus Thompson, Justice Stewart described the right to travel as not a mere condition of liberty subject to regulation and control under conventional due process and equal protection standards, but a virtual, unconditional personal right. But remember, you do not have a right to travel on my property. You do not have a right to travel on anyone's private property. And if the state corporation owns the roadways, that is their private property, and you do not have a right to travel on it. Lost right to travel complaint. So the complaint will not do you any good unless within the complaint you bring up the fraud of the unlawful conversion of the tax revenue to buy the roadways and deeding it to themselves. Then that was the deprivation of your right because it made the use by you a privilege with the money they took from you and caused the deprivation of your right to travel. Took right away. Instead of claiming you have a right to travel, claim that they took the right to travel away from you by this fraud. In some states, the cops just write you a ticket and drive off, whether you sign a ticket or not. In other states, if you do not sign a ticket, you go straight to jail. Duress as affirmative defense. In Delaware, a person can be charged with putting you under duress, and duress can be used as an affirmative defense. It is in the statutes. If you threaten to put someone in jail because they did not sign their name to a bill, then that is a threat and coercion, and that is against the law. It is true in all states. There are also criminal statutes for putting someone in jail for doing the act of coercion. So it is a defense in one mode and a criminal act in another mode. You can utilize either side of it. We are learning how to go back at these people. One of the guys in Delaware drives a truck for a living and he has been talking to the other drivers about using things as without prejudice when signing a traffic ticket and other documents. He told them that whenever they use those words under their names, it created a problem and that the document it appears on cannot be used as evidence. The court cannot accept that document as evidence. Document not as evidence. Without prejudice. From Bouvier's Law Dictionary comes the definition of the word compromise, and from all the cities settled that the letters or admissions containing the expression in substance that they are to be without prejudice will not be admitted in evidence. So if without prejudice shows up on the document, it will not be admitted in evidence. What about an expression not in substance? If you sign your traffic ticket without prejudice, then it cannot be used in court as evidence. If you do not want to get locked up for not signing it, then sign it without prejudice. When you get to the courtroom, bring it up to the judge. Don, the truck driver, told his fellow truck drivers about this, and one of them went only about 25 miles down the road, and a cop pulled him into a weigh station. He checked his truck and discovered that there was no fuel sticker on the truck. Some states charge $1,200 a year for the sticker. It is required to buy fuel in most states. The fine was to be $250. He signed the ticket without prejudice, and the cop drove away. When the court date came up, the cop presented his case, and the judge said, "Wait a minute, I am looking at this ticket, and I want to know if you have any other evidence in this case." They said they did not. So the judge said, "In that case, I am going to dismiss this case. Your ticket cannot be used as evidence." The truck driver could not have argued this case because he did not know how to argue the case. He could not have argued what was meant by using without prejudice. In fact, he did not argue it. The judge took care of it for him. He was lucky that he got a nice judge. Others are not so lucky. Another traffic case in Delaware was heard by the same level judge as the one just mentioned. The ticket was signed without prejudice, but this judge said, "I do not care how it was signed. I do not want to hear any more of your silly stuff in this courtroom. Proceed with the trial, same issue, same level court, but a different judge." Arbitrary law is anarchy. That is an example of there being no law in this country. It is arbitrary. It is anarchy. There is absence or confusion in law all through America today. That is anarchy. Judges have said, the law is whatever I say it is today in my courtroom. Using without prejudice may work for you. If it does not work for you, then there is another way. And we're going to stop right here at cannot force waiver on page 56. I'm enjoying my time with the folks, with you good folks. Please continue to join me. Pages, we're going to read them in full. And that will be the last part of this wonderful document. Oh, man, I'm enjoying myself with you people, man. Anyway, I'll talk to you guys later. Peace and blessings.